In last night's Members Live, I showed you guys the case summary where a lot more documents look to be incoming. A few of them have finally gone public. Let's take a look. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. As you can see, we have several. The first one that we're going to open is this motion for the state to actually exceed the page limit when it comes to their response to the defendant's motion to continue the trial, which we're going to go over that one majorly in this video. Now, the state's opposition is 22 pages. The paper that we just had said it was 17 pages with 5 pages of something different. And I'm not going to read all of this. I didn't read all of the first one, and this is the reason. We can go through this all day long. A lot of this stuff is better understood whenever we can hear the two parties arguing it in real time. On June the 18th, this portion of the hearing is going to be open. So we're going to hear the state, we're going to hear the defense, we're going to hear the court, we're going to hear the argument. I'm not a lawyer. I've never ever claimed to be an expert on any of this information. What I'm going to do is go through and read portions of what they have here so that we can see which portions they're actually arguing, because remember, the defense portion had all kinds of constitutional issues, and then at the very bottom, it talked about the gag leak issue. So we're just going to read the points and leave the hearing to be where we get the majority of the real information. Okay, let's go through the introduction and the factual argument. It is time to try this case. I agree. I know some people are okay with the possibility of it being pushed back a little bit. I'm not. Some of the family members of the victims actually are. Some of them aren't. I'm not. I want to get there. I want the state to have to show their hand. It's time. So I agree. It's time to try this case. Defendant was arrested in late December of 2022 and was indicted on May of 2023. He successfully moved to transfer venue to Ada County. In October 2024, this court entered its scheduling order. There's a footnote, but we'll go in a minute. This court entered its scheduling order, setting deadlines for pretrial motions and expert disclosures. Defendant complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses, and identifying 132 exhibits he may introduce during the penalty phase of trial. That's because the court wouldn't allow them to cut this into 3 pieces and wanted to keep it cut in half instead. If the defense would have gotten their way, none of this stuff about the penalty phase would even be being discussed, talked about, filed, or submitted until after we actually had a conclusion to the trial. All of this stupidity happening is because the court said no and the state wanted to argue things. So let's just keep that part in mind, shall we? Okay, now let's go down to this first footnote. Okay, so it just says, redacted order governing further criminal proceedings and notice of trial setting, just list a document that we've already gone over on this channel. By now, after all discovery deadlines have passed and after the court conducted the pre-trial conference, defendant seeks a trial continuance of unspecified length. That's because the gag order leak has to be investigated. Okay? My interpretation of things is this is getting put in front of the court because the judge is pissed. Okay, so the defense is letting the judge determine just how long, depending on what happens. You can't give a specified length of time for how long this should be pushed back whenever we have no idea how deep all this goes. If the judge is serious about what happened with this leak, okay, he might decide not to go to trial until it's resolved, until the truth is out there, until there's punishments handed out, people in trouble. Or he might say, this is going to go on in the background, way over there in the shadows, and we're going to continue like we should. A lot of people think that's what's going to happen because subpoenas and stuff are being sent out. But we also need to remember there's no decision on if this is going to actually happen or not until after June the 18th. Now, I feel that by the time we get to the hearing, the judge will know the arguments because everything is being submitted. Of course, new things always end up coming out whenever they start talking. Things get discussed and, it just flows a lot better, which is why I really like to wait to get into the depths of all of it until we hear the pros actually going at it all together. But the judge isn't happy. He might decide to do this. We just don't know yet. He bases his request on his claim that his mitigation investigation is incomplete. While state is unable to see whether defendant's ex parte filing to the court contains specifics, his motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how additional investigation will actually produce them. Over on the case summary we saw last night, there has been new something filed that they want used at the trial. The problem is that unless something is on the public page that I don't remember seeing, let me go and look real quick. Okay, hold on. Additional exhibits. Okay, so it's the defense. Okay. The defense has filed more information that they want to have as exhibits for evidence at trial. When the case summary had it, it didn't say which side it was, so we were definitely waiting on the document because the truth is what matters and not what people want to pretend things are, the way a lot of people are still acting. How come we have had the information about the witnesses from Pennsylvania and Washington for like a week now, and there are still channels out there claiming that the prosecution is the one summoning these people to talk against Kohberger? It's literally the defense team. I don't know how many times people have to try to correct people. They're still out there getting it wrong by like the thousands. It really doesn't take a lot to just open the document and read the words. Come on, guys. It goes on to say, overall, the record before the court shows that defendant's investigation has already plowed the necessary ground. While defendant is fully entitled to due process, this court should exercise its broad discretion to deny defendant's 11th hour motion. First, defendant cannot show good cause or prejudice. The leak that you're responsible for? Hello? See what I mean? It's so wild. It's like Santa just wants to pretend that things even exist, which is, ironic in itself. Even under the heightened non-binding ABA standards he seeks to impose on the court, his counsel's resources in investigation to date have been adequate, even setting aside that the defense team still has more time to prepare its mitigation case. Moreover, Idaho's constitution also grants the victims the right to a timely disposition of this case. The court should give these victims' rights substantial weight in considering the motion. How about you care about the victims and give them some information? You are literally the reason, according to Steve Goncalves himself, that they are out here spreading lies and misinformation. It's basically in retaliation to the fact that y'all are not telling the families a damn thing. So if you can go out there and leak all this crap to Dateline and to all these other people in order for all these books and all these things to come out and for them to be able to quote that law enforcement gave them this information, how much do y'all really care? Man, y'all are going to make me more mad than I thought you were. Finally, while the publicity surrounding this trial is a challenge, whose fault's that? You know what? We're just going to continue. We're just going to keep on going. Defendant has not shown and cannot show, oh my God, that continuing this trial will make things any easier. It is just as likely that delay will make it harder to seat a jury. I actually agree with that one. The longer this goes on, the worse it's going to get. That's the only thing so far in this that I've even agreed with. Okay, for all these reasons, the court should deny defendant's motion. Procedural and factual background. We're going to go through this, and then we're going to read the headers for their arguments and the conclusion. And just as with every other document that we read here on this channel, the link for this one directly will be down in the description box. Procedural and factual background. Defendant was appointed his lead counsel in December of 2022. In March of 2023, a second attorney was appointed to represent him. Then, in February of this year, a third attorney was appointed to the defense team. The first district public defender has also been participating in the defense. In addition to his lawyers and their staff, defendant has 2 experienced investigators and a mitigation specialist working on his behalf. In January of 2024, defendant moved for a change of venue from Latah County due to the publicity surrounding the case and the size of Latah County. His motion was granted, and the case was moved to Ada County. On October 9th, 2024, this court issued the operative scheduling order that contained deadlines for motions, expert disclosures, and pretrial filings. I've said this before. I like to say it every time they mention the change of venue. I do think it was a good move at the time, given the way that we were told things were. I'll put it that way. What really told me that maybe we shouldn't have moved venues was the fact that Chief Fry, whenever he ran for sheriff, he lost the election. I felt that if the people of Latah County really felt like Chief Fry did a good job and did this case correctly, they would have had no problem wanting him to be the sheriff. I think that speaks more than like literally anything else. No survey could speak louder than that, in my opinion. Okay. More recently, at the pre-trial motions hearing on April 9th, 2025, the court advised defendant's counsel to ask for more resources if the defense team needed assistance reviewing discovery. The state does not know if this occurred. I mean, honestly, I don't think that's y'all's business. Honestly. Okay. Throughout the case, defendant has been able to comply with the deadlines in the scheduling order. Pertinent to the instant motion, defendant has, on January 23rd, 2025, made his guilt phase expert disclosures consisting of reports from 16 experts, including a psychologist who conducted a mental health examination of defendant and a forensic psychiatrist who researched his life history. That would be Dr. Orr and Dr. Ryan. On March 3rd of 2025, supplemented his guilt phase expert disclosures with reports from 2 additional experts. As of June 2025, has disclosed in discovery over 2,500 photos and videos, over 3,500 pages of investigative material, and many megabytes of electronic data related to the guilt phase. On March 31st of 2025, so we just went backwards. On March 31st, 2025, made his penalty phase expert disclosures consisting of amended reports from Dr. Orr and Dr. Ryan, respectively, plus reports from 4 additional experts, 3 of whom are behavioral health neurology professionals, and, as of June 2025, has disclosed approximately 2,100 pages of purported mitigation materials and identified 55 defense witnesses and 132 defense exhibits for potential use during the penalty phase in this case. They came hella prepared. Defendant also opposed the state's motion for examination of defendant pursuant to Idaho Code 18207 and for an extension of time to complete rebuttal penalty phase expert disclosures, argued May 5th, 2025. At that time, defendant did not preview for the state or the court that he would seek a trial continuance, and the court denied the state's request for personality testing by its expert, in part because the pending trial date conflicted with the time that would be necessary to explore that issue. We went through that entire document, and I don't recall that being talked about. I could be wrong. I could just not be remembering all of the details. Okay, so no one hold me to this, alrighty? All I remember being talked about when it came to this sort of testing being denied was that the defense didn't do it. He wasn't diagnosed with a personality disorder, according to the documents. So because he wasn't diagnosed with the personality issue, there was no further personality disorder testing done by the defense. Therefore, the state could only mirror the testing that was already done, which is as it should be. I don't remember a timing issue. Again, I could be wrong. But that part right there where it says that at the time, back in May, the defendant didn't preview for any sort of trial continuance. Well, that was like before the date that the Dateline boo-boo came out. Literally like, what was that, the 9th? I could be wrong on the date, but I could have sworn it was like May 8th or May 9th that Dateline dropped. So yeah, I guess they wouldn't have said anything before Dateline became public. Hopefully the judge that's so mad about the leak sees that and says, your timeline's wrong. Try again. Timelines being wrong are what the state's good at. Now, this is all of the legal background stuff, and this is the actual argument. Okay, all I'm going to do at this point is read these headlines, the stuff in bold, because again, in a week or so, on the 18th is whenever we're going to be able to hear this in real time and really soak in the details. And honestly, it's how I understand it. a hell of a lot better. So this first one is the court should exercise its discretion to deny defendant's motion because he has not shown good cause for a continuance or that he will be prejudiced at the trial. Good cause is the gag order leak. Let's continue. Defendant's motion is untimely given the procedural posture of this case. Your discretions in leaking information has been untimely every single time you've done it. So shut up. Let's continue. Defendant's purported need to conduct additional investigation is unsupported and does not establish prejudice warranting a continuance. You're leaking information all over the place. According to the defense, who's gone through the discovery you've handed them, there is information regarding someone else that they recently just found based on the timing that you took to get them the information in the first place. Let's continue. The Idaho Constitution's Victim Rights Amendment is another basis to deny defendant's motion. I'm not even going to read this one because I already ranted about this a second ago. They don't care about the victims' families. They are literally driving the Goncalves batty, loony. They need probably to go into some sort of inpatient therapy by the time this is over because of all of the games it seems like the state's actually been playing. I don't agree at all with the way that Steve Goncalves has come out and given a million different things that have been false information. Anything from Bryan Kohberger touching the Wi-Fi to Xana's door being closed. None of those things have been correct, and he has had to come out and admit those things while still not admitting the responsibility for being the reason why all of that caused the dumpster fire that they all caused, but that's neither here nor there. Just the simple fact that the state is trying to play this card is disgustingly hypocritical. I really hope that the Goncalveses are starting to unwind the hypnosis caused here. I'm really hoping so. I'm not seeing it. But I'm hoping that they're seeing it. I need somebody over in that camp to wake up and wake up really, really soon. Okay, so it looks like they are mentioning it here, and it says, there is no doubt that the publicity surrounding this case, including but not limited to a recent Dateline TV show containing non-public evidence, they're not doing this, I am, poses challenges for the court and both parties. The state affirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks, and to assist in determining which person or persons provided non-public information to Dateline. However, defendant's reliance on the Dateline episode to support his motion is misplaced for several reasons. Seriously? Where's the responsibility? There is no way in hell that the state does not know what happened here. There's just no freaking way, okay? No way. They're basically just claiming that whatever's going on in the media isn't going to do anything because of how careful the jury selection process is, and because the Idaho Supreme Court already rejected the defendant's theory that a continuance is necessary in order to allow the coverage to dissipate. It'll never dissipate. They'll have to wait over a decade for people to stop talking about this. Let's be so serious. I also completely disagreed with that one. But that's all that they're talking about in here. And then it goes on to the venue already being moved and the court having such a larger pool to choose from, basically just like null and voids any argument that the defense has. That's not true at all. But they're literally sitting here acting like they don't know anything about this gag order leak. Miss me with the boo-boo, Santa. Okay, so this next one is the state's supplemental notice of compliance regarding exhibit objections. Come now, the state of Idaho, by and through the Latell County prosecuting attorney, and supplements its notice of compliance filed on May 13th, 2025, regarding the state's log or spreadsheet identifying objections to the defense's exhibits. Subsequent to lodging this spreadsheet at the pretrial conference on May 15, 2025, the court requested that the parties supplement this log to include any objections to authenticity. The state hereby provides notice that the state does not have any objections to defense exhibits regarding authenticity, but reserves its non-authenticity objections as outlined in the May 13, 2025 spreadsheet. So they don't have any objections, but they're reserving the objections? She's probably literally only doing that because at the hearing on the 15th of May, we heard that the defense had authenticity issues with some of the state's exhibits. So, they're just being spiteful. Now, besides the fact that they allowed the state to use more pages than they, I guess, were regulated to originally, everything else is completely sealed up. Motion to seal states objection to defendant's offer of proof for the alternate perpetrator evidence. Motion to seal stipulation in order for admission of additional exhibits. Motion to seal defendant's second amended phase 2 mitigation witness list. An order sealing an order, which again is like literally the sealed order staying order dated June 9th, 2025 is sealed. We don't know what that's for. I mentioned that too when it came to the members live last night. Whenever we went over all of these, we have no idea what that's about. It says something about a stay, but we don't know what the stay is for. They are not deciding on the trial stay for the motion to continue that the defense filed until at or after June the 18th, because it's now part of the alternate perpetrator hearing. Originally, the 6/18 hearing was only supposed to be for the perpetrator evidence from the defense. Now we've got a sealed and unsealed portion. So as usual, be ready for this channel to go live to stream the portion that we are going to be allowed to see. I will be in chat like I always am. And then later on in the evening, we will go live and go over all of the basic points. And then we have another order sealing something else when it comes to the defense witness list for the mitigation. Then another one sealing the defendant's motion in order for independent analysis of evidence. Let's see if there's any additional details, though. The court having before it the motion to seal defendant's motion in order for independent analysis of evidence and good cause appearing. Now, therefore, it is hereby ordered that this will be sealed. Okay, but what is it? That's what I was trying to figure out. Like, what is the evidence? There's nothing on there. Considering what we got from the other document, and we do know that there are multiple PIs working for the defense, this must be a bunch of the evidence that came in for the alternate perpetrator stuff. And I guess they need analysis done on it. I mean, it's going to be really interesting if they end up having to actually tell us what this information is and this entire thing goes left. I mean, that's kind of like the point for all of this, right? Let's see what happens. The other one is a order sealing the state's objection to defendant's offer of proof. So whatever was submitted, the state's like, nah, bro, and are arguing it. I really want to read those. Man, I wish I could be a fly on the wall. If Animorphs was reality, I would definitely go be a fly on the wall. That seems to be all of the updated documents so far. I'm recording this right now at around 2 p.m. If anything else pops up, you guys will hear about it. Please make sure that your notification bells are actually set to all so that you get the notifications for whenever these documents do come in. The majority of the time, I will post a screenshot or a snippet about what's going on in my community tab way before I've had the time to record, edit, and post the video regarding the newest updates. So again, make sure that your bells are on for that. Let me know how you guys feel about the fact that the state is pretty much trying to just dance around the whole gag order thing when it comes to their order to go against the motion to continue. I really am curious what they really know. How can they sit there in good conscience and actually argue the leak that the court is demanding pretty much in all of their accusations is coming from that side of the camp? We'll see what happens with it, but let me know how you guys are feeling about all of this stuff down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already, and please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.